Respected Chief Guest, Dr. Vivekanandan Sir, Vice Chancellor, and other distinguished guests on the virtual dais and off the virtual dais. After a very eloquent, in fact, very elaborate PowerPoint presentation and speech by the learned Vice Chancellor, I think my little contribution to this day may not be so assume so much significance, because it has been a very nice presentation from the Vice Chancellor dealing with all the issues. Today, incidentally, I'm given this opportunity, and I should first thank the organizers for giving me this opportunity. I'm privileged to be here with distinguished dignitaries from various parts of the country. And today, incidentally, it is the Human Rights Day, which is celebrated world over, wherein we have the United Nations Declaration on Human Rights, which was adopted on this day, and which is what we call as a very fundamental basic document as far as human rights are concerned. So here, the topic which I am assigned to speak, the contributions of Dr. B.R. AMBEDKAR to the Indian Constitution. It's a very wide area, which with the 15 minutes I am given assigned, may not be able to cover all that very expansive one. But I could tell you that I can just give some insights which I have in respect of his contributions to the present constitution. And before I may go into that, I would say that the human rights jurisprudence all over the world has now come to the concept of opportunity, equal opportunity, not only in status and opportunity, but also in respect of dignity. So it is the human right of dignity which is to be protected, which is being emphasized. The dignity-based jurisprudence is what is being projected all over the world by experts. Maybe the earlier Lady Dean of Harvard, she was an expert in human rights jurisprudence, especially in dignity-based jurisprudence. And we have a constitution which was framed which was given to us initially by the drafting committee, and then which was adopted discussed threadbare by the Constituent Assembly, and adopted maybe as the first parliament of our independent state. The Constituent Assembly has debated it and finally given it. And some of the very important features of the Constitution, what we see are those of the insights and experience which its chairman had. The chairman of the drafting committee, Dr. Ambedkar, had. We see a little parallel between two concepts which are so degrading, so much what we call as outrageous. One is the concept of slavery in the United States, and other is the untouchability we had here. If you ask me whether it was untouchability or slavery which was the bigger evil, well, it would be very difficult to say. Both are such evils that you cannot say that which one is bigger and which one is lesser. Slavery did not involve untouchability. In another way, the untouchability was even worse in one sense, that slavery, people were treated as animals. But untouchability, you cannot touch, you cannot go near a high caste man, and they're all segregation was there in the US, of course. Even equal but separate rule was there for a long period. But it was not that slaves were not untouchables. They could be touched. They did not have privileges. They were treated as animals. But here in India, it was not slaves, but a group of people were found as untouchables. Maybe that is the reason why in the Constitution, Article 17 specifically says untouchability is abolished, which gives a reminder of the back or dark period, which the chairman of the of the drafting committee, he himself has experienced. So there were two instances which is often spoken about Dr. Ambedkar's experience. One is when he as his elder brother got into a cart, and after they moved a little bit, the driver of the cart or the cart owner understood that these two people were from the untouchable caste. At that time, they belonged to Mahar caste, which is an untouchable caste in Maharashtra. So the moment it was realized, both of them were thrown out, and they had to walk the entire way to reach their village. And not only thrown out, they were treated in the most bad manner. And the second instance was when Dr. Ambedkar as a boy, he was very thirsty, and he used the drink. He wanted to drink from a public place, a public well. He took water. For that reason, the upper caste there caught him. He was beaten up, brutally beaten up, because he has polluted that. So he had experience and he never went on to touch it. But fortunately, Ambedkar was born as the son of a army personnel. His father was in the army, and so because of that, he was part of the British army. The British gave certain privileges, as a result of which Ambedkar was allowed to study. He was the first untouchable to have higher education, to go to university to have university education. Though he had to face all this, he had to bear all this with all the social ostracism, untouchability beyond him, people segregating him. He was a single soul person. He endured all this with a pained mind, and he came up with all this. That is where we find a difference with Gandhiji. When we say about Mahatma Gandhi, Mohandas Karamchand Gandhi, he is the face of India, a great man, but he came from an entirely different set. Of course, he also had certain experience in South Africa, wherein he also understood what it means to be a backward class, or to be a bad race or lower race, and what is the difference between whites and the blacks. He also understood. But in India, his position, in the Indian society, his position was good because he belonged to the higher caste, the upper Vedic caste. So maybe there was a different view for him. And throughout the Indian history, we find there was a lot of conflict between Mahatma Gandhi and Ambedkar, and people supporting. People like Arundhati Roy saying that Ambedkar was right and Gandhiji was wrong, and some others saying Ambedkar, and majority saying, and a lot of people saying Gandhiji was right and Ambedkar was wrong. No, it was not personal. It was not merely ideological. It was something social. It was based on principles. Because we know that the history tells us that there were 3 round table conferences from 1930 to 1932. And all these round table conferences, Ambedkar was the only person who has attended. Gandhiji attended only the second one. The first time he did not attend. The third time he was in jail. The first time also he was in jail. He could not attend. The third time he refused to attend, Gandhiji. And one major reason was that while Gandhiji agreed to give separate electorate, it is not reservation as we have now, separate electorate to both Muslims and Sikhs. He did not agree for that, for backward, for scheduled caste or Dalits, as what we call, or for the untouchables at that point of time. So that was a major round of controversy, wherein Ambedkar was stood his feet and said that no, there is no issue of like that. You want the untouchables, if you can provide separate electorates to Muslims and Sikhs, Sikh community and Muslim community, of course, the untouchables who are being so segregated, who are being shunned by the society, by the upper caste people, by the Hindu people, religion, who are not even part of the caste. They are called as outcast. Why can't they have? They should be treated as separate. But Gandhiji had a different view. So Gandhiji initially said, if you read through H.M. Survai, one of the greatest historical document which I have read ever was Legend and Reality, Partition, Legend and Reality, by H.M. Survai. His constitutional law has got an introduction, as you all know, which contains around closely typed around 600 pages. Now there he is very critical of Gandhiji, saying that all the, maybe Survai says the reason for mixing religion with politics, which our country now faces, is because of Gandhiji. He says that he was the person who brought in Muslim fundamentalism into our political movement. He's very critical of Gandhiji. He says that he finds our Jinnah as a different man, and even partition was a result of Gandhiji's reluctance to agree to certain things. At times, Gandhiji was so religious that he would take his inner feeling or his call from the above for stopping his satyagraha. He brought in the Ali brothers, the other one. A lot of things are said, but I'm not going into that. But maybe some may say it has now become fashionable to criticize Gandhiji, but that is not the case with H.M. Survai. H.M. Survai supports all his propositions, all his principles and all his criticism based on documents. Each one is supported by a footnote. What Gandhiji has said in Young India, and Gandhiji also has a change of mind. What he said in the 1920s is not what he says during independence. When Gandhiji said politics and religion cannot be mixed, he used Ramrajya, chantings and all this for the purpose of amassing or getting masses. Later, at a later point, just before independence, Gandhiji changed and said, in Young India itself, he wrote, saying that India, my religion is mine and state is different. Religion and state politics could not be mixed. By that time, it is too late. That is what Survai says. Well, whether I agree to that or not, I'm not saying, but I'm just putting forward one of the greatest constitutional authority in India. Just put a view wherein all this have happened. And in 1925, Gandhiji was in favor of the caste system, saying that it is only the abusing of this caste system what is there. We have to develop this. The outcast should be brought inside the caste system. And then later he changed into the Varna system, saying that they have to be brought in the outcast should be brought in the Varna system and they should be given equality. So an equality within Varna system is what Gandhiji has depended. He has depended on Gita, he has depended on religious scriptures. But Ambedkar was totally against all this. He was totally against the Varna concept. He was totally against the equality which you could maintain by maintaining the Varna caste, or equality between the various Varnas within that system of Hinduism which was then in existence. Even if you bring that equality, he was not satisfied, saying that there were so many reasons. But we should know that that time our constitution, and that is why. But one very important fact, very pertinent that it is, that what we have to keep in mind is, when the drafting Constituent Assembly wanted to have appointed a 7-member drafting committee and wanted a chairman, initially our Jawaharlal Nehru and Sardar Vallabhbhai Patel, Nehru and Patel wanted I.O. Jennings to be brought in and he should head the committee. But Gandhiji said, in spite of all the differences and all these issues which I had, and you know the difference when Yerwada jail, 1932, after the third round table conference, the British agreed to Ambedkar's principle, saying that there will be a separate electorate for the untouchables for 10 years. Gandhiji said, if it is not going to be withdrawn, I am going to fast to death. And Ambedkar stood fast. Ambedkar said, I will not do this. I will not budge an inch from here. But ultimately, because of Rajaji from Madras and other leaders, they all put pressure on Ambedkar, saying that, see, we are already ostracized, we are isolated, we are seen as spies, we are seen as untouchables, and for all this, and if because of us, if Gandhiji is going to die, then our situation will be more precarious. So ultimately, Ambedkar initially said, you cannot blackmail. Gandhiji should not blackmail to put us. Ultimately, Ambedkar went to the jail. Edarwa, the jail, saw and said, I'm ready to withdraw this. And later, it became reservation, not separate electorate. So that is another history. But in spite of all this, and there were a lot of things where Ambedkar, even during Gandhiji's period, had openly criticized Gandhiji openly, and sort of a lot of philosophical. But Gandhiji was the person who advised and suggested the name of Ambedkar as the person to head the Constituent Assembly's drafting committee. Drafting committee, as you know, the 7 members came apart from our Ambedkar. It was K. Munshi, Aladi Krishnasamy Iyengar, Gopalasamy Iyengar, and this we call as our Sadullah, then Madharao and D.P. Keita. And there it was, and there again a lot of conflicts were there. And regarding untouchability and all these things, even before this came in, the Constituent Assembly adopted, and much before it was moved by Patel himself as a bill that untouchability should be avoided, and it should, even before the Constitution came, it was made as a bill, and untouchability prohibition was made into a legislation. But then we should know that our Constitution is in 1950. The US Constitution is in 1789. It came into effect. 1789. That is almost 161 years before our Constitution came into existence. But it took another 65 years, even after the US Constitution came into existence. It took another 65 years for the US Constitution to abolish slavery. And you know what happened? There was a war between the South and the North. The North being led by Abraham Lincoln against the South. And it took 65 years after the coming into force of the US Constitution to abolish slavery. And then you see how many years after that? Another 85 years it took for our Constitution to abolish untouchability. So even after slavery was abolished in US, untouchability was here for another 85 years. And don't have the feeling that untouchability is not there now. Even now we get news from the North, in Bihar and certain other places, we find instances where people are being treated with seclusion, or not allowed to use public utilities. People are isolated on the basis of caste, especially saying they belong to scheduled caste community. So even after 70 years of our Constitution saying so, it has not changed. But same is the case with the US also. Racism has not ended in spite of all these years of US Constitution. But it is in the mind. The Constitution has to come in the mind. Like it has to work through President's conventions. If we are, even after abolition of slavery was not there. But we had untouchability here for a long period till 1950, Finally, officially, we said there is no untouchability. And we have the benefit that right from the start of the Constitution, we have this untouchability abolished, while the US Constitution had to wait for another 65 years before it could be abolished. But we had the other advantage. But we are way back. Well, we had to wait for another 85 years after slavery was abolished to abolish untouchability here. But I would say that one person who has had a major influence was here. But there have been other instances. For example, 370 of the Constitution, which granted special status to Jammu and Kashmir. When that was suggested by Nehru with Farooq Abdullah, he said Farooq was asked to speak to Ambedkar. Now, Ambedkar said, I will not budge to Nehru. I will not introduce this. I will not say. I'm totally against. See, giving special status to Jammu and Kashmir, he was totally against. Ultimately, it was left to Gopalaswamy Iyengar to introduce this in the committee and also place it in the Constituent Assembly. He said, so there were so many provisions which have come in against the wishes of Ambedkar. And the way in which we are interpreting the Constitution may not be in accordance with what Ambedkar has said. And of course, the ghost of judicial review, the heights of judicial review, which the judiciary after Madbury versus Madison in United States have wrested for itself in United States. The same, its ghost is what we see in India, wherein our judicial review is also going above all the parameters and exercising powers without any restraint. And judicial review, you don't call it, they say it is constitutional responsibility. And we know the collegium system. Where do you find this collegium system in the Constitution? It is a constitutional amendment that is made through the judiciary, which is impermissible in law. And there is no executive, there is no parliament which can put unanimously the parliament has come with a commission, it has been struck down and said that the collegium system will continue. Now you know that Ambedkar in the Constitutional Assembly debates and in the drafting committee and in all places, has time and again said, what is the role of the judiciary? The judiciary was only having a very limited role. Ambedkar never wanted judiciary to be given such a role. And that is against that what we find, against the intention of the Constitutional Drafting Committee and Constitutional Assembly ways. We have certain interpretations made by the judiciary. And there's nobody to write. Of course, there are some voices. Recently, Ramnath Kovind, our president, has made some voices. K.K. Venugopal has said about Court of Appeal and Supreme Court being Supreme Court of Appeal and the Supreme Court being separate. And Supreme Court, just like the American Supreme Court, dealing only with a lot of these thinkings, propositions are coming up. But they all have to be understood in the light of what Ambedkar has said. But I would say what Ambedkar said then should always be followed. Because as one of the greatest legends of law, Justice Benjamin North Cardoso said, it is not what the constitutional maker intended at that time, but what he would have intended if he had been now. Same is said with Munro Smith, another great jurist. A lot of legal philosophers said it is the constitutional interpretation. It doesn't mean what the makers of the Constitution said when the Constitution was made, but what they would have said if they had known the present day conditions. At that time, it was bullock cart and horse carriages. Now we have supersonic. So what was said during the age of bullock carts may not fit in the conditions of travel of today's supersonic jets. So what Ambedkar said then may not be relevant, but what Ambedkar would have said if he had known the present day situation. Of course, that is where an imaginary journey has to be made. That is where the American realism is. And that interpretation should not give so much power to the imaginary journey. Through that, whether the judges can wrest an interpretation which can change the total nature of the Constitution, that is another issue. But I can tell you that one of the greatest. I may just stop with saying, if a lot of areas are we discussed, I'll stop with saying that the major contribution, the greatest contribution of Ambedkar has been his concept of protective discrimination, what we call as compensatory reverse discrimination. 16.4, 15.3. Now these are all contributions, and the US people also are using it through affirmative action in the United States. But we have a better system, and in spite of all this, the position of the scheduled castes and scheduled tribes have not improved any further. So Article 14's facets in 15 and 16 have been expanded. Gender-based equality, religious equality, caste-based equality, wherein when the caste system for so many years where you have to compensate for that. If I go to history, maybe another 2 hours I can speak on the atrocities that have been committed, which are even greater than what we see in Jai Bhim. The film, a must-see film. The atrocities which have been committed during the earlier days. Read Romila Thapar. Even in Kerala, read what our Sridhara Menon in Kerala history. Nowhere is an exception in India. And Ambedkar has been his concept of political, social, and economic justice. It has found its place in Article 14, 15, and 16. Then in the directive principles where socialism, state-sponsored socialism has been set, that has found its way, which is now in air with our with the 19s with Narasimha Rao. But of course, because the Constitution says at least there are certain measures that are being given. Then regarding the federal structure, he always wanted the center to be strong in emergency only, not otherwise. For preserving the unity, he wanted a unitary system, but the center to be powerful only during those periods, not always. And his major contribution, I would say, was the system of parliamentary democracy, which we had. And of course, we could say it's a parliamentary sovereignty, which is being undermined right now because of the larger stress on judicial review and the self-assessment, the self-engrancement which the judiciary itself has made for judicial review. And with these words, I conclude saying that we have a constitution where a lot of the fundamentals of this constitution, especially with regard to equality, protecting human rights from an angle of the depressed, downtrodden, oppressed, have been protected. And of course, we have a constitution which guarantees parliamentary democracy as envisaged by Ambedkar, but undermined by the concepts of judicial review as incorporated here. Since Keshav Singh's case, maybe incidentally I would say from the 70s, Keshav Singh case, judiciary was asked to decide on the issue of the question between parliamentary sovereignty versus judicial review. And ultimately, the advisory opinion ruled in favor of judicial review, undermining parliamentary sovereignty. But still 1990, till the hung parliament came, the judiciary did not have the courage to poke into the parliament. But now, after Goro Singh Babu was cheated to come over to Delhi and meet to appear with Supreme Court, things have changed. That is another issue. But I would say that the concept which Ambedkar had in the Constitution and the basic concepts are now being changed. And there will come a very strong executive or parliament. Maybe at times we think somebody like Indira Gandhi has to come, though I'm a total critic of Indira Gandhi because of the emergency she had. She had undermined the Constitution. But there has to be somebody like that to put the Constitution back on track, to make sure and say the judiciary that See, the constitutional fundamental principles, you may have declared the basic structure. You cannot go on discussing basic structure one day this way, that way, and add to it like this. The basic structure is what we have understood. This is constitution. The parliament knows. The parliamentarians now are the Ambedkars. And what Ambedkar intended then and what he would have intended now, we will decide and we will say. And that will give us, put in place the constitution which envisaged by Ambedkar before us. And hope the judiciary will hear this one day to say that the guardians of constitution should know that this is what has to happen. And the parliamentary democracy which was stated by, that should be given utmost importance. And judicial review has to have its restraints. And separation of power is not a myth or a forgotten doctrine or an irrelevant doctrine. It still has its place. There should be checks and balance. There should not be judicial autocracy. There should not be judicial dictatorship. There should not be executive dictatorship. There should not be parliamentary dictatorship. Now, there should be check and balance. Each one should be having, who is going to check the judiciary? The parliament and executive are being checked by the judiciary. But who will check the judiciary? There has to be mutual checks and balances. Somebody has to check the judiciary also. They should be made accountable to each other. There should be a system in place. Maybe Ambedkar did not visualize this. He has visualized separation of power. That is why he has said all his debates, all his comments, all his statements in the Constituent Assembly would show that he wanted a strict separation of power. He never intended such a situation where one wing of the government could run without controls. And that is why they should also be made accountable. All the three wings should be made accountable. There should be mutual checks and balance. What Ambedkar envisaged, maybe if he had envisaged that, he would have brought at that time itself some checks and balances to ensure this. With these words, let me thank the opportunity, the organizers, especially Safi Mohan, for calling me and giving me this opportunity. I'm privileged to be among you. It's a good, all our learned audience. Thank you, sir, Vice Chancellor, sir, for being with me for my speech. Thank you, sir. Thank you very much.
Thank you so much, sir, for your absolutely amazing